Next matter to come before us this morning is State of Ohio versus Jack Arnold. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve that time and let me know, and when you get started, I'll be keeping the clock this morning. We've read the briefs and are ready to proceed when you are.
May it please the court, my name is Natasha Guerreri and I represent the appellant of the state of Ohio in this matter, and I would wish to reserve 3 minutes for rebuttal. This matter deals with the state's appeal of the trial court's decision finding that the OVI specification as applied to Jack Arnold in this matter violated equal protection. Jack Arnold was indicted under 2 separate theories of operating a motor vehicle under the influence of alcohol or drugs. Both felonies of the 4th degree, because he did have 5 prior OVI convictions or convictions of similar statutes. And each also had an OVI specification attached. Mr. Arnold then filed a motion to dismiss the OVI specifications pursuant to his 8th District Court case, State of Ohio versus Columbus, in which that court found that equal protection was in fact violated for the attachment of these OVI specifications because there was potential for disparate treatment between similarly situated defendants, as well as the fact that the proof that was required for both the offense as well as the specification were identical, and that would allow for the state to basically choose what type of punishment they were picking for each individual defendant. The state then filed 2 motions in opposition to the dismissal of the OVI specifications, and the matter was actually submitted on the briefs. No testimony, no hearing was actually held. And based upon the briefs, the trial court in this matter granted Mr. Arnold's motion to dismiss the specifications. Here, the state has alleged 3 separate assignments of error in this matter. The first of which is that the trial court found that the OVI specification was not rationally related to a legitimate governmental interest, and the state argues that that is in fact not the case. Arnold did not allege that he was in a suspect class or that a fundamental right of his was implicated with regard to the OVI specification. Therefore, the appropriate analysis would be whether or not it rationally related to a governmental interest. And the legislative distinctions are only invalid if they bear no relation to a state's goal and no ground to be conceived that could actually justify that particular legislative distinction, and that statutes are presumed to be constitutional and should be liberally construed. Courts should liberally construe the statutes in order to save them from any sort of constitutional infirmities. This court in State versus Midcap, although did not address the equal protection argument, did address a double jeopardy argument with regard to the specific specification RC 2941.1413. And in that matter, in Midcap, this court did find that that particular specification did reflect the legislature's intention to create a penalty for a person who has been convicted of multiple OVI offenses, that it was the legislature's intent to provide additional punishment for a person who repeatedly went out and drove drunk or under the influence of some sort of drug.
Well, what if the state had a legitimate interest and they passed some legislation related to that legitimate interest, but it doesn't have the effect that it's intended to have, meaning it doesn't punish people who have had a certain number of OVIs differently than it punishes the same people if not charged with specification. I mean, isn't it unconstitutional if it doesn't accomplish its stated legitimate interest?
Is it my understanding that you're looking at, I guess, treatment between different offenders, Your Honor? or.
Right, and I know that we moved over top of the suspect class argument into the legitimate interest, but can it not be unconstitutional because it doesn't accomplish the legitimate interest?
If, in fact, it does not relate to a legitimate government interest, then yes, in fact, it could be unconstitutional, but the state arguments that that's definitely not the case here, because it is the intention, and this court has held that, in fact, this statute does, in fact, achieve that interest of punishing those offenders who are multiple repeat offenders, as well as protecting the public from these individuals. And the court in Columbus also acknowledged the fact that this particular statute does relate to a legitimate government interest, and in fact, recently, after my initial brief was submitted in this matter, but in time for my reply brief, the 12th District in State versus Hartsook also addressed this Columbus type issue as was here, and they indeed also found that this particular statute did serve a legitimate governmental interest because it is there to give that increased punishment for those offenders who constantly are going out and violating this particular statute. Therefore, with regard to that, the state would argue that the trial court, in fact, erred in finding that there was no rational relation to the governmental interest, a legitimate governmental interest. With regard to the second assignment of error, the court found that the potential of any sort of disparate treatment between similarly situated defendants also implicated the equal protection, Mr. Arnold's equal protection rights, and the Ohio Supreme Court in Wilson has held that prosecutorial discretion in and of itself does not violate equal protection. It is up to a defendant in order to show that other similarly situated offenders were not pursued against for the same type of, who are in the same situation, as well as showing some sort of purposeful and intentional discrimination against that particular defendant. And again, the Hartsook is just one that I will be going back to, because that court dealt straightforward with this equal protection argument with regard to the OVI specification, that in fact they disagreed with any sort of contention that the Columbus court did find that it denies equal protection just because the prosecution has the ability to either insert or not insert this OVI specification. And here, Mr. Arnold did not present any sort of evidence to the court that other defendants in his same situation of having 5 or more prior OVIs were not given the specification, or that he was intentionally discriminated against personally by the state, and therefore because he failed to prove these two elements that were required for an equal protection violation, that the court erred in finding that the potential for any sort of prosecutorial discretion violated equal protection. And with regards to the third assignment of error, the court relied upon Columbus again with regard to the specification and the actual underlying offense having identical proof of the specifications to prove both the offense as well as the specification. However, the court in Columbus relied upon State versus Wilson, in which the Ohio Supreme Court analyzed when two separate offenses, two standalone offenses, require the same type of activity, the same type of proof in order to find the defendant guilty. And that type of situation where there's two separate offenses where one could have a different punishment than the other, then that in fact does violate equal protection. However, Because we have a different situation here where we have an offense with an attached specification, the specification itself is not an offense, it's an attachment to an increase in punishment for the underlying offense. And while the Fifth Court in State v. Mail didn't address OVI specifications in and of themselves, they addressed another situation of specifications, and in that particular case, the Fifth District did say that the specification is not a separate offense. It should not be analyzed under Wilson. It's just a procedural requirement to show, put the defendant on notice that the state is seeking this additional punishment. And again, in State v. Harstook, the 12th District also found that any sort of application of Wilson to the OVI specification should not apply because it is in fact a specification and not two separate offenses that would be analyzed. And that the language of the specification and the offense themselves clearly indicate the General Assembly's intention to authorize this cumulative punishment for those repeat offenders who clearly have that history of going out, drinking, or being under some sort of influence before operating a motor vehicle.
Well, isn't it the repeat offenders that the state deems should be punished differently than repeat offenders that the state has decided not to punish differently, the prosecutor's office?
And I think that, Your Honor, does deal with that second assignment of error, where it's the potential of, and a potential of in and of itself is not a violation of equal protection. There has to be some sort of evidence presented to the court to say, you know, there's these class of other offenders here. They're in the exact same situation that I am, but the state decided not to pursue them. But they pursued me, even though we're in the same circumstances, because, you know, they are intentionally discriminating against me. And that's a proof that we do not have in this case.
Well, do we really need it where we can look at the elements of the spec and the offense and see that they're identical, which does lead to the conclusion that the prosecutor has the unbridled discretion to decide who gets charged with the spec.
I think it is definitely still necessary in that situation because there has to be some sort of, you know, proof to show that that's what it is, you know, that it's the prosecutor saying, you know, this particular offendant I don't like for whatever situation, you know, I'm planning on giving him this specification, this additional mandatory time versus these other defendants.
So the defense is in a position of going back and doing the research and saying, well, the last 10 defendants who were charged with this spec all had brown eyes, and you know, the ones that had blue eyes didn't get charged, and so therefore it's a violation of equal protection, and I'm prejudiced by it.
Yes, that is definitely a burden borne by the defense to be able to say, you know, here, I've noticed this pattern, this is the pattern, here's the evidence of that pattern, therefore this violates my equal protection rights. Not just throwing out there that it could be a violation of equal protection, but I don't have the evidence to support that particular argument.
And counsel, you are in your rebuttal time. Do you?
Thank you.
Good morning, Your Honor. May it please the court, my name is Stephen Hannadel. I represent the appellee, Jack Arnold. The OVI statute as applied in this case is unconstitutional on its face, and so therefore we don't need to provide any evidence of disparate enforcement because the statute as it's written provides two separate punishment schemes for the same group of offenders. And that is for the offenders who are accused of committing their 6 OVI in 20 years, the statute provides two separate punishment schemes. You know, one group, at the choice of the prosecutor, one group could be subject to mandatory prison terms of anywhere from 1 to 5 years. The other group could get 6 months to 2.5 years, 60 days in jail, 6 days in prison, or even probation.
But isn't the choice of the prosecutor, it has to do with timing of the offenses, doesn't it?
You mean as far as like the 6 and the 20 years?
When the 6 occurred in that 20-year span.
Yes, and it matters as to whether the prosecutor decides they want to charge a person with a specification. So, they may not charge a person with a specification, and therefore they're subject to the maximum of 2.5 years of incarceration, but as little as getting community control and walking free. Whereas if the prosecutor says, no, we're going to charge a person with a specification, suddenly they're subject to a mandatory prison term that's anywhere from 1 to 5 years. And yet, it's for the same offense. There's nothing to distinguish between those who are charged with a specification and those who are not. They're accused of committing their 6 OVI in 20 years.
But isn't that a different set of facts?
What's that?
Isn't that a different set of facts, though? Maybe an OVI, but it's not your first, it's not your second, it's not your third, it's the 6th.
Yes.
So
but,
there's a different set of facts on this day as there was the last time.
Yes, I mean, I'm just talking about this particular group. The group of people who are the 6 and 20 offenders. That just this group alone. Within that group, we're treating people differently, and there's no
when their 6 offenses occurred.
Well, I don't know if there's any distinction as to if it's their 6 and 20. There's no distinction as to who should get charged with a specification or who shouldn't. If you were to put all the 6 and 20 offenders in one group, then, and it doesn't matter whether let's say they had a high test, low test, or if they caused an accident or anything like that. If it's just a straight up OVI offense and that's number 6 in 20 years, there's nothing that the statute does not provide a mechanism as to who should get charged with a specification requiring mandatory prison time for up to 5 years versus those who shouldn't get charged and possibly get probation. So, and that's where it's unconstitutional on its face because it does not rationally relate to a legitimate government interest. There's no legitimate government interest in the state just randomly picking and choosing who they feel like they want to punish more and who they want to punish less. That everybody should be, the same group of offenders should be subject to the same punishment scheme. And then that discretion then would then lie with the court. It shouldn't lie with the state. And as I wrote in my brief, the confusing wording of the statute, which the statute seems to repeat itself in multiple times, in multiple places, is that, but ultimately it is clear when they use the word or in 4511-19, they use the word or in 2929-13, it is 2 separate punishment schemes. And it's purely at the choice of the prosecutor as to who can be subject to that, and there is no criteria that's laid out in the statute as to who should be subject to the potentially harsher punishment and who shouldn't. And, when we deal with other specifications, like a firearm specification, for example, that requires, the use of an operable firearm. Let's say if you commit, let's say an aggravated robbery, that's like, that requires a dangerous weapon or ordinance. That could be a knife, that could be, a toy gun, it could, be a number of things. But if you have an operable firearm, then that specification would subject you to an additional 3 years. That's different from this case because that firearm specification requires an extra element that the underlying offense does not require. In this case, the specification is identical to the underlying offense. And
which of the subsections of the specification the state charged the specification under? Which of the subsections of 4511-19G1 that the state charged the specification under, since there's more than one way in which you can charge the specification?
There's really nothing in the statute that directs the state when they should charge the specification and when they shouldn't.
Right, but once they've made that decision, they have to point to something in the specification statute that says this is why this person, this case carries this specification. There's more than one reason that they can charge the specification in the statute.
I would say that the reason the charge in the specification is the same reason the charge for the underlying felony OVI offense. If it's number 6 in 20 years, then the reason's the same. There is no. It's a felony of the 4th degree to have a 6 OVI in 20 years, and yet for the specification, all it requires is 6 in 20 years. There's no extra element as to maybe it should be for somebody who has number 6 with a high test, or somebody if they cause, a wreck. In their number, while they commit their number 6 and 20, nothing. It's both the criteria, the statutory criteria, the elements are identical for the 4th degree felony offense and for the specification. And so there's no rational legitimate government interest in the way the statute is written that could anyway be accomplished when you're subjecting the same group of people to different schemes of punishment. And the Ohio Supreme Court has pronounced in State v. Wilson that 2 separate punishment schemes for the same group of offenders is unconstitutional. And I also would like to make the point, too, that I think that the statute violates Mr. Arnold's rights of double jeopardy as well. And I challenge this court's decision in State v. Midcap from 2006, because when you look at what Midcap was based on, it followed a first district decision in State v. Gonzalez, which then followed a U.S. Supreme Court decision from 1983 in Missouri v. Hunter. And I think the first district misread Missouri v. Hunter. Missouri v. Hunter dealt with Missouri's equivalent of a firearm specification, which I just said earlier is different from this case. And so ultimately, we have a situation here where Mr. Arnold is being subject to double punishment for the same offense.
Back to State v. Wilson, you acknowledged, did you not, that that case involved actual offenses and not specifications? The analysis was 2 separate offenses, not an offense and a specification.
I don't know if that's really I don't know if that's really the right analysis in terms of when you're trying to say 2 separate offenses. I think that the proper analysis is that there's 2 different punishment schemes for the same conduct, for the same offense. And we're looking at a man who's accused of having a 6 OVI in 20 years, which one statute says felony the 4th degree, he could get anywhere from probation up to 2.5 years of incarceration. Then you got another statute that says, oh, if you get the specification which requires the same thing, he could get 1 to 5 years in prison. And then some interpretations might look at it that he could potentially have both, and it could be potential to 7.5 years in prison. And so, and again, there's nothing in the statute that spells out who should get charged with the specification and who shouldn't, separate from those who are just charged with the 4th degree felony. And I think that's why the statute is unconstitutional on its face, and therefore Mr. Arnold does not have to present evidence of disparate enforcement, because when a statute is unconstitutional on its face, then there is no need to provide proof as to how it's enforced. I think that's all I have. If there are any questions, I'm more than happy to answer them.
Seeing none, thank you.
Thank you.
Counsel, you have a little under 2.5 minutes.
Thank you. Just in relation to Attorney Hannadell's argument with regard to the facial challenge, he's alleging that Mr. Arnold made a facial challenge to the statutory scheme of 2941.1413, and the court in Hartsook did address that particular challenge in that case. And again, the court there, basically goes back to the prosecutorial discretion, I apologize, argument, which basically the defendant has the burden of proving the circumstances that the statute could not be valid, that there is some sort of discriminatory actions against that particular defendant, and here's the proof. That goes right back to that particular argument. And the state would just ask that, based upon the arguments made here today, as well as the arguments made in the brief, that this court reverse the decision of the trial court, finding that there was an equal protection violation of Mr. Arnold's rights, and have the matter proceed through the process with the specification intact. If there are no further questions for me. Thank you, Your Honors.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website.